Thank you very much. Good morning and welcome everyone to this, the 11th meeting of the Justice Committee in 2013. And I ask everyone to switch off mobile phones and other electronic devices completely, as they interfere with the broadcasting system even when switched to silent. Apologies have been received from David McCletchy, and John Lannard is attending as his substitute. Item 1, the agenda: decision to take business in private. Are you agreeable to taking item 6 in private, which is what's my item 6? Yes, consideration of the Scottish Court Services proposals on future court structure. Are you agreeable?
Record from that why you want to do it in private?
Well, this is proposed private matters. It includes consideration of potential witnesses who may be invited to give evidence to the committee. And I'd also, frankly, like the clerks to be able to talk about processes if people feel that the committee is not agreeable to some of the proposals, what the processes are in Parliament for dealing with it and at committee. And it's quite difficult if the clerks can't speak, and I thought that would be useful. That fine? Thank you very much.
One point of information. You know that I wrote a letter to you about the legislation in connection with sectarianism in football grounds. I'm grateful that you're able to put it on the agenda for next week. I wonder if we could have some indication of a cut-off point for intimating to the clerks when we want something on the current agenda.
Yeah. As you know, I think I saw this on Friday, and I'm happy to accommodate you. As you know, any member can raise anything with the clerks, who raise it with myself as convener, or in fact with me directly, to put something on the agenda. It's a matter for my discretion whether or not to include specific items which have not previously been agreed as part of the work programme. However, I don't want to disregard the views of any member of the committee, and certainly didn't, as you know, with yours. But I was kind of balancing about what we had in the agenda, and I've already gone through the timings of what we have in the agenda today, and it's very tight, and felt that we must put it on at the earliest opportunity. Had it been really urgent, and I have to say my FMQ, I put in for an FMQ and it was refused, so obviously the PO doesn't think it's urgent, then I would certainly have tried to do it. But I was thinking of members who might not be able to access their papers, not be looking at them till late, they wouldn't be prepared. And as you know, there's a separate matter. I'm looking for some guidance as to what the position would be if the Crown, if we started to discuss the recent case and the Crown were to put an appeal in, what the position would be about being sub judice. So I'm kind of looking at that. So it will be on the agenda next week. Fully intend to hold that discussion in public.
And Thursday morning, at least, it can be considered.
It's far better, and of course it was also recess, and I was aware that members might not be back to look at it. So of course, and as you know, it's on next week, which is Timaeus, I think.
Can I just briefly add to that, convener? I mean, I think probably all members have received a lot of correspondence about this and policing of football over the last couple of weeks, and just to put it on the public record that, you know, we are concerned about it and want to discuss it at the first opportunity.
Well, that's what we're doing. Thank you, not all. Moving on now to item 2 in the agenda. And this is our first evidence session of the Victims and Witnesses Scotland Bill, and we'll hear from 2 panels of witnesses on the bill today. And I welcome to the meeting our first panel, David McKenna, Chief Executive of Victim Support Scotland, Clive Binning, Executive Director of Field Services at the Scottish Court Service, David Harvey, Director of Serious Casework at the Crown Office and Procurator Fiscal Service, and Superintendent Graham Clark from Safer Communities Police Scotland. I have to say, Superintendent Clark, I love the way you spell your first name. Mine is always misspelled. Is yours?
Always.
Good. We're in the same team then. Thank you all for your written submissions, and I go straight to questions from members. Please, Rod.
Morning, panel. This question is really specifically for David McKenna. It's on the question of reviewing a decision not to prosecute. The bill itself provides under Section 3 that victims will be able to ask for information in relation to a decision not to proceed with a criminal investigation, any reasons for it. Are you contending that the EU directive goes further and saying that having been provided with this information, somehow or other victims should be able to challenge that? And at the end of the day, is it not the case that the Crown, in public interest, must take a decision on whether or not to proceed with criminal charges? Perhaps you could expand a bit more on this issue.
Can I just add, sorry, I might say your microphones will come on automatically if you indicate to me that you're being called. Mr McKenna.
Yeah, and I think what we are saying is that the European Directive on victims requires that victims have the right to have a decision by a prosecutor not to prosecute to be reviewed. And indeed, I believe that in Scotland, the Crown Office and the Lord Advocate intends to introduce just such a measure here in Scotland.
Face there, does that?
Yeah, no, well, you're giving me information which, obviously I'm unaware of. Where did you get the information in terms of the Lord Advocate?
I understand this is information that's been provided to this committee. I don't know.
I'm not aware of that information being provided to the committee, no. However, we will be, that's a question, we can put it now on the record, yes.
Follow that through. Yeah, that was just
put your gas up people a wee bit, that, didn't you? We're just out of recess, go easy, We have been working, but not in committee. Colin.
Thank you, good morning. My question's actually, I suppose Mr Binning might be the person who may be able to help us more on this. One of the things that came across in a round table meeting we had with some witness victims a wee while ago was that of the actual structure of the court building themselves and how they're treated once they actually get to court. And there were some instances where people who had been victims of a crime were effectively shown into a waiting room or area that the alleged perpetrator was in the same space, and it was providing quite a bit of difficulty both emotionally and obviously in space terms to try and keep clear, and they felt quite intimidated. Perhaps you could enlighten us as to what steps have been taken in the past to try and avoid these situations arising in courts, and in terms of the future, perhaps you could tell us if there's an ongoing plan to avoid situations like this happening.
And certainly it is true to say that there are instances, and they are unfortunate instances, where that occurrence does emerge. Thankfully, they do appear to be very few and far between. The reality of the position is that certainly in the High Court and in the main sheriff courts, there is a level of accommodation provision that actually makes it a matter of course, really, to ensure that there is segregated provision for Crown and Defence witnesses. And from that perspective, there is a degree of safety and assurance that can derive from that. There is probably more of a challenge in the smaller courts to provide that level of segregation. But the one thing that I do want to assure you and the committee of is that we take all possible steps to make sure that this kind of occurrence does not arise. That is through a combination of actions, for example, by being alert to the potential prior to the trial, by issuing notice to reception and court officer staff, and making sure that in the course of the conduct of business there are patrols of the precincts of the court to make sure that eventuality does not emerge. So we seek to do everything practically possible to avoid that kind of occurrence.
You said that it only happens in a small number of examples of this. In terms of the High Courts particularly, and in senior sheriff court trials, obviously there's a fairly high turnover of court cases within these properties. When you say a small number, what are we talking about here?
The number of instances we have received reports of are probably less than 5 a year, to be honest with you. We become aware of them through representations made at the time of the occurrence or through later representations in the form of complaints. But certainly the number of reports that we have of this occurrence is, as I say, thankfully very, very small. And I would say less than a handful a year.
It would happen in the smaller courts, or has it happened in High Court situation?
I am aware of one instance where it has happened in the High Court over recent years. where there has been an unfortunate circumstance such as that. But certainly, though, in the main, the number of occurrences are very, very small in proportion to the number of cases that are dealt with. It's certainly not one that is indicative to us of what could be termed a systemic or systematic problem, because, as I say, we do take all practicable steps to make sure that this eventuality doesn't materialise.
Does any other panel member wish to comment on that?
Yeah, I think I would agree that certainly in recent years the propensity for witnesses to be mixed in terms of prosecution and defence witnesses has significantly improved. I think our experience, though, is that it is still inconsistent in terms of that policy actually delivering in practice. And we regularly have reports of witnesses being not separated, and there are a couple of areas where it seems to be particularly obvious, which is in Falkirk and in the annex in the Aberdeen Court complex. These are two areas which I don't know, Cliff, if you're aware of that.
Did you report these to Mr. Binning?
Well, we routinely draw all our concerns about the care and treatment of witnesses to the attention of the Chief Executive on a regular basis, and we have a meeting with the new Chief Executive tomorrow.
Certainly, as a matter of course, what we do invite David and other organisations to do is to raise these matters with us when they occur at the time.
That's my question. I do find it quite astonishing that, considering the adversarial nature of many of these instances, that a situation can be not avoided, that these people are actually in the same room together. It does seem rather odd, and I hope it's something that is dealt with.
I do want to make sure that I make my own position clear here, and that is the incidences where victims and accused or witnesses of the accused find themselves in the same room would be exceptional. There are situations where in the precincts of the court building there can be occasions where they are in the same place at the same time. Again, we take studious steps to avoid that, particularly in cases of vulnerability, where on request and in consultation with the Crown, we take strident steps to make sure that segregation occurs at all times of the day.
I don't want to put Mr. Harvey on the spot, but I let it slip past when the remark was made that the Crown Office are actually considering, having review of cases on the call of, as it were, of a witness. If they are not going to prosecute, are you able to assist us in that or not? I mean, if you don't, you can't. But I mean, I thought you're sitting there with the Crown Office.
I'm very happy to be able to assist, Chair, if I may, and welcome the opportunity to do so. The situation from the Crown's perspective is that the current arrangements which we have in relation to the procedures that are available to victims and witnesses and being able to challenge particular decisions that are made are already compliant with the terms of the directive. But having said that, there's always room for improvement, and so the Crown Agent has commissioned further research in relation to that to establish whether or not further improvements can be made, and indeed whether or not a system of formal review would be something that would enhance the current position.
There we are. Cleared it up. You happy now, Mr. Campbell? We've got it cleared up. You weren't listening. He wasn't listening, and that was for your benefit. Just the last line will do for Mr. Campbell's assistance is that you're reviewing.
We're already compliant, but we are looking at enhancing what is already there, and so the Crown Agent has commissioned a review.
There we are. There's your embarrassment over for the day, Roddy. Graham, followed by Sandra, John Finney, then John Lamont. Graham.
Good morning, panel. Thanks for coming in this morning. I've got 3 or 4 areas I'd like to cover if we've got time. The first one in relation to victims and witnesses. At an earlier session that we held here in private, we took evidence from people who had been involved in the system and had first-hand knowledge. And there was a very strong message passed to us, which not only indicated a concern about their security within the courts when they were there to offer evidence and so forth, but the point I want to cover separately from the one that Colin covered earlier was a notion that they felt like they were treated like a parcel that was being passed between various services, that the police dealt with the first line, then passed it on to the Procurator Fiscal, victim support sometimes got involved in it, VIA got involved, victim support from within the Crown Office became involved, but they felt that there was no continuity of knowledge and a feeling that there was something round about them that managed their needs and their interests, and they were left adrift as they passed through the system. And some of these cases were very serious cases which involved a great deal of stress. There could have been no doubt in anybody handling these people. This was a real serious case and they felt under tremendous pressure, but they felt the system distant from them. Do the panel want to comment on whether or not what is proposed within the bill will resolve that, will enhance the provision of the service, or are there other matters that this committee should bear in mind when trying to improve the circumstances for victims and witnesses?
Yes.
I mean, this really goes to the heart of the greatest concern about the experience of victims and witnesses in the formal criminal justice system, and it's widespread sense that the justice system does not provide recognition for the experience of the individual and doesn't demonstrate respect and doesn't treat the individual with dignity. And critical to that is that the people who are coming in contact with victims and witnesses in the justice system need to be properly trained to understand the impact of their behaviours on that individual. We all know how to show dignity and respect and recognition to the judge, to the prosecutor, and indeed to the other officials in the court. We are not so good at showing that respect and recognition to the very witnesses and the very victims about which the system is actually in place. So training, and we have it in our response, everyone who comes in contact with victims and witnesses needs to be trained.
Anybody else wish to comment? Mr. Harvey?
If I may, Chair. At different stages in the investigation and subsequent prosecution, different authorities will have the most up-to-date relevant information. So initially that will be law enforcement when it's being investigated, thereafter the prosecution phase, and then thereafter towards the end it will be the court service. And certainly from the prosecution perspective, and picking up on Mr McKenna's point, obviously the primary interaction from the Crown perspective is through VIA, and those are fully trained professional staff. I am aware that there is consideration and exploration of the possibility of for want of a better phrase, an online case information hub, which agencies would contribute to and would become a one-stop shop. One of the key issues being, of course, the multiplicity of agencies and individuals that people have to deal with throughout the process. Obviously, as with all matters, online is not necessarily the solution to every individual, particularly some people who are particularly vulnerable. But however, it is an opportunity to provide up-to-date information throughout the process with the various authorities contributing, and that's certainly something that the Crown is keen to support further work on.
Else wish to comment? What about the police were mentioned? I think it was the flow. I mean, you're all aware of what's happening, but for people, this is a foreign land, and they're there to assist the prosecution. And our example was some of these people were still very traumatised years on.
And where that happens, that is indeed regrettable. I think the bill presents Police Scotland with an opportunity to provide standardisation and consistency. We have good practice out there in each of the 8 legacy forces, and we do provide victims and witnesses with information where that fails or where they don't feel they have enough information, I think the provisions of the bill will enable them to ask for that information and creates the footing for them to get the information. But moreover, I think it forces us or it compels us to come up with standardised levels of service that we will deliver. So we will take all the good practice that's out there, which in the vast majority of it is good practice, I think, and certainly some of the recent work that was done by HMICS indicates that victims and witnesses are on the whole content or satisfied with the information they get from us. But I think it's about driving that. It's about recognising the needs of witnesses. It's about, as David says, recognising their dignity, treating them with respect, and trying wherever possible to make sure that they don't feel that they are being parcelled up and passed on to the next person in the process. And I think my own view is that the bill goes a considerable way to trying to make that happen.
Going back to David, my question at the end was, will this bill make the difference then? Could you just give us I think
the bill has the potential to make the difference. And again, it's about putting in place some systematic processes about ensuring that all victims actually get access to support services. Those support services are the principal means through which victims actually get advice and support and actually understand their rights in the criminal justice system. Most victims will tell you that they have to tell their story time and time again. We think around 16 times they have to tell their story. Everyone tells them everything will be all right. Well, it won't be. It's not going to be all right for many, many people. So the experience of victims is that they need to be treated with recognition and respect. They have to have access to effective support services. And I have to say, it doesn't matter who it is in Scotland that's working with victims and witnesses. They are not properly trained to support victims and witnesses. Not even the victims' organisations, not even my organisation, because we need to invest more money in ensuring that that training is the best possible training and is effective in delivering not just for the victims and witnesses, but justice in Scotland.
Three specific questions, one for Mr Harvey. Victim notification scheme is mentioned in the paperwork here. Can you tell us how many people have accessed the victim notification scheme since its inception, and some idea of how it's working and how successful it's been?
I'm sorry, Mr Pearson, I don't have that information to hand just at the moment. I wonder if I may come back to you with that, with an answer to that.
Either later in the proceedings or to write to us with the information,
I'm obliged,
please.
It just seems to me it's been a very important concept, and one would have thought we would have had a clear view of how well that's been received by victims, how many people have accessed it, and how much success they deem has resulted as an outcome. The surcharge concept that's mentioned within the bill, would any of the panel members be able to give us some insight into whether or not it would be proposed that all offenders would be subject of surcharge? In terms of the bill, would people, as have been mentioned elsewhere, road traffic offenders, would they be subject of this surcharge?
Yes.
Yeah, I'll go first. Our position is that everyone convicted of an offence in Scotland should be asked or be required to contribute to the fund to help victims. I appreciate there are arguments about what that surcharge might be and how it might be applied, but it's certainly our position it should be as wide as possible.
Motorists will be involved in it too.
Sorry, yes.
Motorists will be involved in it.
Our proposal would be that it's as wide as that.
Mr Harvey, have you any indication from your own point of view?
Not from that perspective, Mr Pearson.
Okay.
If I could just clarify that, as I understand it, the position, the surcharge will be applied to court-imposed penalties, and I'm not aware of any limitation on the court-imposed penalty.
Yes, I'm scooping up everybody's questions. But
sorry.
If you want to be unpopular, go ahead, Graham.
You know me, I like being unpopular.
Yes, I think it's your modus operandi.
Restitution orders are mentioned within the bill, which is a new departure. From the point of view of being a devil's advocate, Police Scotland, do they see any conflict of interest here where police officers will be prosecution witnesses and the outcome of a court case may end up with a restitution order being put in place where facilities and services provided to police officers will be paid for by an accused at the end of a court case?
I think, Mr Pearson, as an organisation, we're broadly supportive of the proposal for restitution orders. However, subject to some more information about how it's going to operate, because I absolutely agree with you that unless it operates in a manner which is, there is an absolute firewall between the court proceedings and how the restitution is made, then you do open us up to, or open police officers up to, an accusation of conflict of interest. My understanding, having spoken to the government, is that the restitution orders will be placed in some form of fund which will be administered on behalf of the officers. So whether that's going to be through the Police Welfare Fund or whichever, as long as it's done at an arm's length and we avoid that very conflict of interest that you highlight, then yes, we would be generally supportive of it. But I feel we do need slightly more information round about how that's going to operate before coming down conclusively on it, sir.
I see also, I think in terms of that section, reports have to be made by the Scottish Government. So there is a kind of watching brief on what's happening in it as well. Yeah. Sandra, I don't know if there's any questions left for you, but go ahead.
Well, I've got an answer to a couple of them. Thank you, Graham. That was very kind of you. But I did want to come in a supplementary to Graham's original one about the standard of service before I went on to my more substantive question. A number of witnesses have given evidence regarding the standards of service, and I think Mr McKenna touched on that. And a number of witnesses have said that it should be a duty that's put on the face of the bill, how witnesses are treated, rather than being more open-ended to basically the judges or the sheriff's interpretation of it. I just wondered what opinion you had on that, if it should be a duty that's actually put on the bill.
Yeah, I mean, this is a very complex area, and it's really an issue about whether such standards ought to be in the bill or whether they should be in some other form of regulation. And I think certainly the evidence from England and Wales, from other parts of the world, is that in the main these regulations, other than when they are procedural rights, are actually in these standards are actually in regulation. And I think that would be a good first step for Scotland. If they were in regulation. I think putting on the bill is maybe writing it in concrete when you don't want concrete.
Is there any other panels of witnesses? Sorry.
Mr Harvey, yes.
Thank you, Chair. Insofar as Section 1 and Section 2 are concerned, which set out the general principles and the standards of service as they currently are, the Crown has already published our commitment to victims and witnesses and customer feedback policy, etc. So these are matters which we've already taken. I appreciate that's a different thing from being on the bill, but certainly we're comfortable that the ethos behind the bill is being approached in the correct manner, and that our commitment and our position in relation to the levels of support that should be on offer are publicly available.
And
Clark wanted.
yeah, likewise, I think I would share that view, that I think the ethos of the bill is correct. I think that we will very shortly publish exactly what the standards we are going to achieve and that we are going to deliver, and I think that will absolutely be in line with the ethos of the bill. So my own view would be no, that it's not required within the legislation.
Yeah, I just want to be very clear that I don't believe that the present arrangements for ensuring standards of service to victims of crime by the statutory agencies in the criminal justice system in Scotland actually work. They have to be by regulation, and there has to be a reporting mechanism so that most victims do not know these standards exist, and they do not know how to complain if they believe those standards had not been met. And even if they could complain, it's not clear at all of what the remedy for that complaint might be. So I believe there should be a requirement for regulation, and that regulation should be in such a way that it's actually agreed by the Parliament.
I completely understand. I just, the varying witnesses' statements, some had said should be on the face of the bill, others have said no. So I just wanted to get a feel for that from this panel, perhaps ask the same question of the next panel if Graham doesn't come in first and use that one. But my more substantive question, and Graham had taken a bit about the restitution orders, and obviously it was answered very well to my satisfaction anyway. The victim surcharge was the one that I wanted to ask about. A number of representations have said that they didn't think it would be workable as a fine. Perhaps it would be better as a, going out into the community. But obviously, yourself, Mr Binning, your evidence has said that there's been an improvement, in court fines, etc. So I just wondered, the panel's, their views on that, about the victim surcharge. Is it absolutely workable then? Would we be able to get the money in?
Certainly from the court service perspective, we are confident of the capacity we have to recover financial penalties. The position is a strong one in the context of financial penalties across the board, and the recovery levels of sheriff court fines, for example, after imposition are such that they are reaching 86%, with evidence of improving. For Justice of the Peace Court fines, they are at 81% and improving. The one thing I do want to emphasise is that we are not by any stretch of the imagination complacent on this, because in addition to what we regard as creditable performance, we have a number of steps in hand to actually improve on that, including, for example, gateways to information systems held by other organisations. We are in dialogue currently with the Department of Work and Pensions in that regard. We are in dialogue with the DVLA in the context of driver information, and we have a number of process and technology improvements in hand to make financial penalties easier to pay. So that I would say in the round we are confident of that proceeding with and on an ongoing basis, and we do not see that the surcharge would be in any way an impediment to that whole process.
Yeah.
Comment on victim surcharge, Ms McKenna.
I would agree with Cliff. The international experience is that when you introduce a penalty that's about returning something to the victim, the actual recovery increases. So what we should see is it go up from 86% to 90%, 95%.
Yeah, can you just clarify, it's not going to the individual victim?
No.
Just for the record, because I think people who follow this might think, some people actually pay attention to this.
It will go to an individual victim, but not directly from the
Exactly, yes, just to clarify that in the record, yes. You're happy just now. I've got John Finney, followed by John Lamont, and then Alison McInnes.
Thank you, Convener. Good morning, panel. I'm interested in individuals who have literacy issues and how the present system deals with that, and how this proposed system will deal with that. And one of the difficulties, of course, is people identifying themselves as such, but I wonder, could I have your comments on, given the volume of paperwork invariably any system generates, how literacy issues are dealt with, please?
Start with that. Perhaps, yes, you're one of the first ports of call having to work out whether someone's able to understand what's happening.
Absolutely. I think that as an organisation we will try and identify any vulnerabilities with any victim early, because the sooner we can identify any vulnerability attached to that victim, the sooner we can make sure that we take steps not only to address that vulnerability, and that may be in terms of literacy issues, it may be in terms of safety of the individual, it may be in terms of the wider their vulnerability within the criminal setting. We can begin to put steps in place and share that information with partners. We're well into the routine of picking up vulnerabilities like that, of putting them in a police report, so that any assistance that's required, be it interpreting, be it literacy, is flagged up early within the police report and makes its way to the Crown, so that the Crown can begin to take measures. It's not, obviously doesn't fall within the special measures in terms of the legislation, but that wider vulnerability is something that is looked at, and wider safety of the victim is something that is looked at early doors by police officers when they are compiling a police report.
Move on in the process to the Crown Office when you receive this report. Do you have this information always, or sometimes you get surprises?
Well, I think as with all systems, you occasionally will get a surprise if that particular issue hasn't been raised by the individual at the time, or it hasn't been apparent to the officer concerned. And it may well be that, that the issue arises at a later stage in the process when we have that initial interaction with the victim or the witness. And at that stage, it would be a question of putting in place measures to make sure that there was appropriate oral communication with the individual and making sure that they had the necessary reassurances. So there is an understanding that there isn't just an automatic reliance on the information that is provided by the police, and that staff are aware that if further vulnerabilities are identified that weren't in the original police report, that those then need to be considered and addressed, whether by way of the way in which the individual is giving evidence, which in that particular one may be of less significance in the majority of cases, but actually it's much more to do with all the other processes that go round about appearing as a witness, whether that's completion of forms in relation to expenses, etc. And those would have to be taken through by the individual concerned and the member of staff concerned.
Kenna.
Yeah, I mean, I think this is, again, we'll probably disagree with my colleagues. I mean, I think certainly our experience is that many of the vulnerabilities, many of the needs of victims and witnesses don't get picked up in the formal process. And to be perfectly honest, our view would be that the police service and indeed the prosecution service, indeed the courts, are probably not the best way in which to ensure that these assessments are actually undertaken. And so, we believe there should be a single point of contact from the beginning that provides a continuum of support and care and assessment of need across a broad range of areas, so social, economic, financial, justice issues, relationship to offender and so on, and to ensure that the victim doesn't have to tell the story every single time, again and again and again, but also to ensure we have a joined up picture of the needs of that individual, and that the preparation can take place in advance of their interaction with the justice system at its various stages. So our view is there should be an assessment process. It should be formal, it should be wide-ranging, and it should be one that follows the victim through the whole process.
Thank you. One of the principles set out in the face of the bill, and I'll quote it to you, is that insofar as it would be appropriate to do so, a victim or witness should be able to participate effectively in the investigation and proceedings. Could the panel tell us what that means for each of them or their organisations or their overall view? Particularly interested in the phrase participate effectively in the investigation.
Yes.
Yeah, I'd be happy to start off. I think it is about, I've heard Mr McKenna speak very often, and I think each of the criminal justice organisations asks a lot of victims. We ask them to do a lot, and we ask them to do it an awful lot of times. I suppose it's about making sure that that individual feels respected, feels supported, feels that they have a voice, feels that they understand what's happening to them, and feels that they are confident to go forward and perform what is their civic duty in a liberal democracy and give evidence in a court of law that leads to a conviction.
Anybody else wish to comment on that?
Yeah, we don't know what that means either, and we feel that word should be struck from the bill.
And as the convener says, people do pay attention to what takes place in here. For instance, Mr Harvey, would you have a view? Would you be soliciting the support of victims and witnesses to assist with any investigation?
Forgive me, I was actually looking back at the original directive to see whether or not that's perhaps where the wording had come from. The answer to that, of course, is yes. We would, of course, be looking for them to participate effectively in investigation and proceedings. I can only think, and this is without looking in detail at the directive in that particular respect, that it may be something to do with, in connection with where there may be a tension in relation to a wider public interest decision, that there may sometimes be a perceived issue between the individual's view and the view which is finally taken. But that's the only situation I can think there might be any qualification, and I have to say I tend to agree that it's not.
I didn't understand your explanation, and I was paying attention.
Indeed, I suppose that when you have situations where, for example, you have a variety of victims and witnesses who perhaps have different perspectives about what the outcome should be, then it may well be that some of them may feel that they are not participating as effectively as others, depending upon the nature of the outcome. But beyond that, I find it hard to know what that wording means.
I'm more confused than when we started. Thank you for that, John.
I'm glad I'm not alone with that. Many thanks.
Which section is that? You've got us all in.
That is from the SPICE briefing. I'm reading from page 7, Statement of General Principles. And it's the fourth bullet point.
Mr. Clark, you want in? Yes, while I'm. Yes, my head's hurting.
I mean, I think I had taken a much more simplistic view of that statement, that it was in fact a statement of empowerment for victims. But I think the fact that there even is confusion may be something that's worthy of reflection, if not everybody understands exactly what it's intended to mean.
Yes. Sounds like just soft words that don't mean awful much, but we'll challenge that. Well, thank you, John. John Lamont, followed by Alison, then Jenny, and then Roderick.
Thank you, Convener, and good morning, gentlemen. My question relates to something which Graham Pearson has touched on already. It's the victim notification scheme, and the suggestion from Victim Support Scotland in their evidence that more information should be routinely and proactively offered, and it should be extended to all victims of criminals given a custodial sentence. Sorry, given to all victims of criminals given a custodial sentence. And I just wondered, firstly, to Victim Support Scotland, if you could detail a bit more about the types of information, or sort of information that you would expect to be routinely made available, and secondly, to to Mr. Binning and Mr. Harvey, whether you see a resource implication as a result of that additional information being made available.
Ms. McKenna, you're first.
We appreciate that it's a very challenging order to ensure that victims are provided with appropriate information at every stage of the criminal justice process. But certainly we know how important it is to victims and to communities who are affected by the crime to have information about what is going on in their case. So from our perspective, we would want victims, for example, to be aware that an individual had appeared in court and had been bailed or not bailed, that an individual had appeared in court again for any reason, or had been released from prison for any purpose. So, for example, to attend a funeral, for integration back into the community, for work purposes. So really basically to ensure the victim's informed all the way through the process, right up to and including parole.
I understand a bit about not being told someone's been bailed when a condition of bail would be that they don't approach the victim or be in a certain area or something.
And if you go to Sheriff Court and sit and look at the process in court, a hearing takes about, 45 seconds, 50 seconds. So, and the victim doesn't even know that hearing's taking place, and there's no information available to the court about the risk or threat or the security issues in relation to the victim because it's never been gathered, and so the court's not able to take account of it. So the least that can happen is that the court or the appropriate agency can advise the victim that the individual has been bailed or not been bailed.
So, sorry, you're making a different point. So if a condition of bail is that they don't approach the victim or be in the vicinity, they would, surely the person, the victim or witness, would be told that that was a condition of bail.
Nope.
How could they know? How would they then know to report them for breaching it?
Exactly the point I'm making. So the ideal situation is that when bail is granted, that the safety and security and the concerns of the victim should be taken account of when setting bail conditions. That doesn't happen at the moment.
We knew that. And Mr. Harvey, can you perhaps take us further with this?
I think that's with respect to somewhat sweeping statement. The position is that if material is available through the police in relation to a particular vulnerability having been identified, a particular risk having been identified, then the court is invited to apply particular conditions. and that the nature of that risk, if that risk is known to the prosecution, is shared with the court so that they can take an informed decision on how to manage that risk, with bail being one tool, remand being another. So if that information is available, then it is placed before the court.
Yes, but is the person then told, if that becomes a condition of bail, is the person who is one of the witnesses that this person who's been bailed is not to approach, blah, 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 as a condition of bail, not to be in a street, a certain street or whatever?
Special conditions of bail should be intimated to the individuals concerned.
Mr. Clark?
Yeah, particularly around domestic, where we have domestic crime or violent crime. We have got a relationship where we are informed of special bail conditions on the day of the court, and they are delivered to the victim that same day to advise the victim and to also cater for the victim's safety planning. Because if we have somebody that we have highlighted poses a risk to an individual and they are back out, then we need to begin to look at how we can plan for the safety of that individual.
Mr. McKenna, you were...
Madam Convener, I think you should invite the Crown Office and the Police Service to give you information about the levels of information that's provided routinely in the Sheriff Courts in relation to bail cases, because my experience is, unless it's a very serious, violent or sexual crime, it is very unlikely that anything will be said in court. And it's with double respect I say to David, that it's not to say it doesn't happen, but it rarely happens.
Invited them, Mr. Harvey.
I'm not quite sure what exercise we're being asked to do, but I'm certainly willing to explore it further and explain the position as it stands.
I think the other point I would make as well is that not every... I mean, we're making a supposition here that every case has a bail condition. That's not the case.
I honed in on a bail condition.
Yeah, you know, many
applied to witness or victim.
Many cases there will be no bail conditions to keep victims away. I think
standard bail conditions. Standard bail conditions for every case. They're standard. Yes. Every case has standard bail conditions. Yes. Which is not to interfere with witnesses.
We will ask you to expand further on what is said to potential witnesses and victims, and the victims and witnesses are often the same person, as we know will be the same person, on what actually happens when there are bail conditions that are put that they should know about, so they can tell if they've been breached, and also have some sense of security that at least this person's been put out on bail and can't come up my street. John?
I would also seek to add that in the return we'll also explain the process whereby if a particular risk is highlighted, that is made aware to the court as the public authority, because the public authority, the court, has its own responsibility to not only the accused but equally to the victims and the wider public. And so therefore it's crucial that they have that information, which I think we fully accept. If it's available, it should be placed before the court.
Yes, well said.
So, I mean, one might argue that it should always be put before the court, that in fact there should be a victim safety assessment done as part of the court papers that are provided when bail decisions are being made. Now, I appreciate the complexity of that, the very short turnaround. All I'm saying is that victims and witnesses do not know in general about the fact that someone has been bailed, and they do not know about standard conditions, never mind any special conditions.
Leave it at that for just now, John. I'll take you next, Alison. You're next anyway, so we'll just take John.
My second question relates to sentencing and transparency in sentencing, and I appreciate sentencing is a very complex issue, but I'm also very conscious that from the perspective of victims of crime, it's something which is raised, certainly from my own perspective as a constituency MSP, there's a lot of frustration about how sentences are handed down, and also the practice of automatic early release. And I just wondered if you think that this bill is perhaps a missed opportunity in this regard, and what your thoughts are on sentencing and how that could be dealt with more effectively.
Well, we would certainly say what we have said for a number of years, and we have called for this, that there should be a sentencing commission in Scotland which actually sets out what can be or should be expected in our courts in terms of sentencing. We don't comment on individual sentences. We never comment on the individual sentencing of convicted individuals. But what we would say is that while you'll never necessarily get a victim to agree with the sentence, and when it comes to families of murder victims, for example, I've never spoken to a single family that actually agreed with the sentence, no matter what it was. But surely all victims have the right to understand how that decision was arrived at, and that's what we would ask, that they should be supported and informed, so that when a decision is taken, even if they don't agree with it, they understand how it arrived at that.
Comment on that, the understanding of what has been the outcome for the... Nope, right. John, any more? Alison, followed by Jenny, then Roddy.
Thank you very much, Convener. Just to follow up from the debate we've just had there on the back of John's question, if you could also provide the committee with information on where the responsibility lies. Is there a single responsibility? Is it with the police or the court, Crown Service to provide this notification in relation to bail conditions? That would be useful as well. Turning to my own question, the bill provides for the provision of special measures for vulnerable witnesses. But it also allows the right to object to those. I wonder if the panel could explore quite why that right to object should be there, and what particular problems that brings for witnesses. I would find that interesting.
Victim Support Scotland, and I believe in common with all other victim organisations in Scotland, strongly object to this proposal in this bill. We believe that it will undermine all the good work that was delivered through the Vulnerable Witnesses Act, that it will present a substantial barrier to witnesses to get access to special measures, further distress them and lead to a reduction in the quality of evidence that they actually give, and possibly even result in future in witnesses not willing to participate in our justice system. And if there was one part of this bill that we believe should not be there, it's that.
Chair. To echo the comments that Mr McKenna's made, to the extent that the measures are most welcome in relation to the extension of the provision of special measures, and in particular the extension in relation to the use of the notices as opposed to the applications. I simply pause to reflect, though, that if it's a notice, and what the bill is attempting to do is create a level of expectation and certainty for those who are children, but also those who are deemed vulnerable, it does seem odd then that there is that right to challenge in respect of those who are going through that notification process. That is not to say that there shouldn't be an opportunity for the court to review how a particular thing is working once it's actually running on the day, and I think that that's a separate provision as opposed to the right to challenge. And so the efficacy of the measure is always subject to the court's assessment. But beyond that, the right to challenge, particularly in relation to those who are deemed vulnerable, does seem to run contrary from the Crown's perspective to the intention of the bill.
Helpful, thank you.
Can I be difficult and say, but what about the defence here? I mean, you're innocent until, presumption of innocence till proven guilty beyond reasonable doubt, and all they're alleged victims in terms of court procedure. And also some witnesses are not nice people. They're not all nice people. There's some people who are criminals themselves who are part of the proceedings and so on. Is it not appropriate that there should be, I mean, I'll challenge that, appropriate that courts may feel that at least has a right to challenge whether or not someone is should have the security and things as a vulnerable witness to just test it. I mean, I'd be a bit concerned if, in terms of ECHR, there was not a right for the other side to have that tested. I mean, I can see the point of this. Now, many people who are now working for the Crown also once worked as defence advocates at some point in life. So, without putting you in a difficult position, is this not a balance we must remember in court?
Having in my career worn both hats, Chair, and indeed, and separately, regardless of which chair you happen to be sitting in, convention compliance is crucial to both, and both sides of the table should regard themselves as human rights lawyers. The position from the Crown's perspective is that it's a different situation when one's dealing with a notice as opposed to an application. If we're talking about a situation where we're looking for either additional special measures, or you're talking about those who are not deemed vulnerable, then under the current system, the Crown expects to have to be able to justify why that special measure is necessary. So it seems sensible that there is equally the corresponding right to challenge that. But in terms then of the key right that is being protected for the accused persons in proceedings, I come back to the point I made earlier, which is that in the end it's the public authority, it's the judge in court who has the responsibility to make sure that the proceedings before them are Article 6 compliant and that there are fair proceedings. And so there is always that opportunity through the review process, once the thing is actually up and running, for the court to be able to say, actually, the way this is working today, this is not going to be effective and there is an issue that may result in a prejudice to a trial. But separate to that, and that would be in a truly exceptional circumstance, what this gives is the opportunity for those vulnerable victims and witnesses to have that level of certainty and that level of confidence that these measures will be available for them in giving evidence in court. And one of the key issues in any justice system is surely to make sure that whoever it is that's giving evidence, whether it's an accused person, a victim or another witness, that they are comfortable in doing so to the extent that they are able to give a true and accurate account of their recollection of events. And this proposal, insofar as it relates to the notification scheme, and subject, as I say, to the removal of the right of challenge in respect of those notifications, goes a long way to achieving that aim.
Rod, do you want to come in on that point as well?
Mr. Harvey, I obviously looked at your written submission when you touch on a case which had human rights implications. I'm not entirely sure whether you think Section 9, the objection, should be removed, or is it possible to amend it and save it to provide that balance that you were talking about?
Insofar as Section 9 is concerned, what we're talking about here are the difference between notices and applications. And so if Section 9 were to cover a situation where it was the application for any additional special measures where the Crown would have to be in a position to justify its position, then that would be something that I think could reasonably expect it to be subject to challenge. But this as it presently is framed, allows for a right of challenge in respect of those measures which, even at present in respect of child witnesses, are effectively routine and are not subject to challenge.
Convener, we appreciate that it's important to ensure that however evidence is presented to the court, it doesn't lead to an unfair trial for the accused, but also that it promotes best evidence possible. And in practical terms, in the 21st century, what we're really talking about here is that someone can give their evidence from behind a screen, or in the witness stand in the court, or from a closed-circuit television room in the court. Now, it seems to me, if that promotes the delivery of best evidence, and there is no evidence that it affects the fairness of the trial in relation to the accused person, I don't even know why these should be special measures. These should simply be measures through which you can give evidence in a court in Scotland. Most people, and we work with 80,000 witnesses a year, most witnesses want to go in and give their evidence and get out. So our view is that the answer here is to allow everyone to use the existing measures, that's screens, CCTV, or the witness stand to give evidence. End of story.
Right, we've been through that one now, so I've now got Jenny, followed by... That was your question, was it?
Basically that area, yeah, so I'll withdraw that.
So you withdraw yours, so Jenny now, please.
Good morning. Mr Binning, what will be the impact on victims and witnesses of court closures?
In the context of the bill, it's important to put a number of considerations into context here. One important point to make is that the redistribution of business, which is consequent on the Sheriff Court or proposed Sheriff Court closures, amounts to 5% of the overall business of the courts, and I think that's an important point to make. It's also important to reflect on the fact that in the context of the proposed jury reforms, the position is that 86% of court business already takes place in the centres that are recommended. What that implies, first of all, is there are two things here. One is that the impact is very, very confined. The other is that the business is redistributed to the remaining courts. Now, as far as resourcing or capacity is concerned, the main elements of activity which derive from the bill relate to the extensions of special measures, the notice and the consequent handling at various stages. Now, in the context of the notice and the approval by the court, that is very much a quick and administrative procedure that is actually dealt with by the Sheriff in Chambers. So there are no real resource impacts in that respect that derive from the bill. In the context of the availability of measures, which is really the next stage in process from the court's perspective, it's also important to put into context the actual level of demand which will occur at the time of the trial. Now, there is conceivably a potential for 18,000 applications to emerge in a level of provision, but there are some very important points to bear in mind. One will be the proportion of trials in respect of which evidence is actually led, and the proportion of trials that result in the leading of evidence is between 15 and 20% of the population of cases raised. The next point to draw out would be the concentration of business, and in any event, the concentration of business will be in the busiest courts, and that's why we have made the provision that we have in the busiest courts for additional screens, and we are confident that under whatever regime emerges, that we have the capacity to deal with the special measures.
McKenna, you wanted to...
Yeah, I think our position is that in terms of responding to the consultation exercise, that we indicated that we believed that the court closures would further inconvenience witnesses and victims, and we were concerned about additional travel. And we also noted that, I don't know if you're aware of this, but if you take your car to go to court as a witness, you won't get your parking charges paid. And nowadays that can be £10 or £15. So we knew it could involve additional travelling time, and we also were concerned that in terms of using public transport, you could often have the accused and the victim travelling on the same bus or train. And we also recognise that 15 years on from the witness service being introduced in courts, it's time to look at what we've learnt about looking after witnesses, and it doesn't start when we sneak them in the back door of the court. It's time to look at how we support witnesses in the home setting, in the community setting, and then into the court and back out again. The court programme closure possibilities have initiated a meeting which is taking place, I think, tomorrow with the Chief Executive of Scottish Courts.
The detail of that, because we are going to deal with...
Okay, well, we're going to look with Scottish Court Service.
We will be calling witnesses.
Okay, we're going to look to see how we can mitigate that impact.
Question to Mr. Harvey as well.
Thank you. The position, insofar as capacity has been concerned, first of all, we've been involved from the outset in consultation with the court service, and on the capacity point, and taking Mr. Binning's point about in relation to the volume of casework that is conducted within these courts. The other courts would be in a position to cope with that without significant increases in any delays in the processes. Insofar as the witness expenses point is concerned, witness expenses would continue to be available and to be paid per the existing guidelines until such times as they are changed, but that is the position that we have with that. I suppose that the point I would pick up in relation to the travel to court point is that the same applies really in all of the courts where we are at the moment, whether you're coming to Glasgow or Edinburgh or whatever, there is always that risk, and there's a local community incident, then people will tend to be getting the same bus, regardless of whether it's a big city court or somewhere in a small town. The same risk applies, and that again, regardless of where that particular case is being heard, and going back to the points that are made previously, those are precisely the kinds of points which need to be addressed in terms of making sure that there is the witness safety and security.
Yeah, I think that's what I want to focus on with the court closure thing is, you know, the isolating witnesses from each other, because, and I don't want to go into this, we can go into this next week, but there are cases, and I think Mr Binning and you will know, and those of us who've practised know that there are some courts where the whole building is so old, it's almost impossible to separate people because of the nature of the building. So there are issues there which don't assist witnesses and victims, and there are also instances where I think if we're looking at potential closures, it will be to the detriment of witnesses and victims. So, you know, but I want to leave this, if you forgive me, Jenny, because we're going to be doing this and taking panels, certainly something different, just to say we will be taking evidence on this. We hope to have 3 panel sessions, 3 sessions on this, so it's not closed down. We will be going into that. Jenny.
Thank you, Convener. We heard in our private session from victims of crime about delays in court, and having sat in Sheriff Courts myself, I've seen this at first hand, and also colleagues have been putting in a number of questions to the Scottish Government on the cost impact of delays in court. We heard from one victim about a time that her case was delayed 6 times. This impacts on lost days at work for both victims and witnesses, and severe inconvenience. Can I ask specifically first to Mr Binning how this type of delay can be avoided now, and how it can perhaps be reduced under the proposed legislation?
Context of delay and the expeditious dealing with prosecutions in the court processes, there really is currently an unprecedented energy across a whole range of fronts to make sure that delays are kept to an absolute minimum. Under the Making Justice Work programme, there is a whole series of projects which are calculated to ensure, for example, that all measures are in place to ensure that witnesses appear on the appointed day. From the court's perspective, we are absolutely determined to make sure that we optimise the programming of court business to avoid delay, and in the context of sharing information, sharing approaches, optimising of processes, there are real strong efforts to make sure that the delays are kept to an absolute minimum. And as a matter of course, there is now a reporting on a whole range of information, specifically in the overall time lag from case initiation to disposal, to provide that we all collectively keep our eye firmly on the ball in ensuring the expeditious delivery of justice.
Has your organisation, Mr Binning, done any cost impact on, you know, the impact of delays? This is information we're told the Scottish Government doesn't hold, but I presume your organisation maybe does.
We're guided by a number of sources. One of the most instructive recent sources was the Audit Scotland report on the criminal justice system, and that was a very instructive document from the perspective of all agencies to actually highlight the cost to the system at the various stages of process. And it's one that certainly the Scottish Court Service and I'm sure colleagues are all very alert to, and that is one reason why there is a very determined effort to bring about systematic improvements to the whole process.
Targets for that are set.
So, excuse me a minute, I want to get back to the bill, which is the Victims and Witnesses Support Bill, and I want to know the impact. No, Jenny, I'm sorry, I want to get back to the impact, which is a very important question you asked, on witnesses and victims who turn up time after time to find that they're losing their wages, the thing's not going ahead. Why is that happening? How can it be improved? And what are they told at the time? When they turn up. And I think that's from the point of view of the bill is what we'd like to know.
Let me explain. What I'm trying to elucidate is if there are measures in place to reduce this, to reduce the inconvenience for victims and witnesses.
That's fine. That's exactly what we want to find out, and why these delays happen and how we get rid of them. Mr Harvey, you must have experience of this.
Indeed, Chair. Thank you for the opportunity. Mr Binning's already referred to the Making Justice Work programme, and there are a number of activities under that heading precisely to deal with what is classically termed, but in somewhat derogatory term, I have to say, of churn, which really doesn't take into account. And I see Mr McKenna rightly smiling at that. That's obviously from a system perspective rather than the individual's perspective, and that's why I'm saying the word in that term. But when you're looking at the system, that's the way in which you try and address it, but with the imperative of trying to improve the experience of the victims and witnesses to try and get the case resolved as early as possible. So, for example, one of the reasons for that might be that witnesses lose citations or for other reasons don't attend. So one example that has been very successful is the texting of witnesses in advance of their court appearance to make sure that they're aware and reminded that of the need to attend the court, because very often that attendance at the trial can be the very matter that ends up focusing the mind of the accused person into deciding whether or not the matter is proceeding to trial or whether or not it's a matter that's capable of resolution. So actually getting the witnesses there can be a crucial aspect of that. Equally, in terms of court loadings, you don't want to have a court that is too heavily loaded and then you invite too many witnesses along that you're never going to get to. So again, there is quite significant work on studying what is the optimum weighting of a court to make sure that actually there is a prospect of the witness being able to give evidence if the accused appears and all other witnesses appear. Then there is a prospect of that case actually proceeding.
And who tells people, who tells the witnesses, this isn't going ahead today, it's 4 o'clock, the sheriff's going home, or whatever, there's another case, trial going ahead, your one is postponed. Who keeps them in explaining what's happening? Mr McKenna, perhaps you can...
I mean, it's really important to know that a lot of activity is going on around getting witnesses to court, and we support that agenda. I think the real challenge for us is those witnesses that manage to get to court but don't manage to take part in the criminal procedure in that court. And so, we are regularly aware of witnesses who are called time and time again. And do you know how soul-destroying that is for an individual? Do you know how difficult it is to keep phoning to find out whether you've been countermanded or not countermanded, whether you have to go in tomorrow to try and get through on the phone times, and then to go in and actually find your case isn't going ahead. So that we need to understand the huge burden this is placing on witnesses in our criminal justice system and do everything possible to alleviate that. And I believe a lot more could be done. But perhaps what is most wasteful is the number of witnesses who turn up to give evidence in court and sit there all day and then told to go home at 4 o'clock in the afternoon when they could be told to go home at 11 o'clock in the morning. And we experience that. Cliff, you get a chance to say something in a minute. We experience that on a regular basis. Yes. So no, thank you. It's too hard. but we experience this on a regular basis because the court is so busy. No one finds the time to go down and discharge the witnesses, and that's another issue we want to talk to the Scottish Court Service about.
Just to try and get an answer to my question, that's exactly why I asked: are there targets to reduce the churn?
Well, let's let Mr Binning get to the bit first of all, before we get to any targets, just to answer why people are not told at 11 o'clock in the morning and sit till 4.
That's my question.
And then you can get yours.
There was a couple of points. One point that I want to deal with is the number of occasions where cases are adjourned because of pressure of court business or lack of court time. Now, in that respect, we do have a performance measure, and we do monitor that rigorously, and the position is that less than 5% of cases set down for trial are adjourned because of lack of court time. I'm not suggesting that's a model of perfection, but I think it's very important to put that into proper context. As far as the position of trials being adjourned on the day is concerned, then for whatever reason, then clearly it has to be unfortunate. My understanding of the practice is that when a trial is being adjourned, steps are taken on two fronts. One, to advise the witnesses who are in court, and secondly, to receive information on witness availability. Now, I do take David's point that it may well be not always the case that that is communicated properly and effectively to witnesses. As to the specific question of whether or not it's appropriate to adjourn a case at 11 o'clock or 4 o'clock, then again, ideally, a decision will be taken at the earliest opportunity. There is an inherent unpredictability in the conduct of court business, and what we all have to do is make our best judgments in the best sets of circumstances. And there may well be occasions where the preferable course of action is to allow a longer latitude of time during which it may be, for example, that negotiations on a plea could take place. So it's not always cut and dried, and there is not necessarily a conscious effort to keep people waiting until 4 o'clock. Again, as a matter of routine, usually at the midpoint in the day, a judgment is taken in consultations between the Crown, the bench and the clerk as to whether or not it's appropriate for the loading to be maintained. I don't see these things don't happen, but it would be quite wrong to say that we don't make serious attempts to manage what is an uncertain situation.
No. Okay. Well, I thank you very much for your evidence, and thank you for your written submissions as well. And we'll adjourn we'll rise for 5 minutes, 11:20, a little break. Right, back we go, and can I thank everyone and welcome to our second panel of witnesses. I know who sat through that first evidence, and feel free to comment, I'm sure you will. That's what we want. Sandy Brindley, National Coordinator of Rape Crisis Scotland; Louise Johnson, National Worker Legal Issues at Scottish Women's Aid; and Peter Morris, who submitted petition PE 1403 on improving support for victims and witnesses and has campaigned on this issue for a number of years. And we agreed to consider your petition, Mr Morris, as part of our scrutiny of the bill. And there you are, persistence pays off. Can I thank you also for the written submissions, and can I ask members for questions? Sandra? It's all right, Graham. Excuse me a minute. Graham's got a self-denying ordinance here to at least come in at number 3 or 4. So, Sandra.
Thank you, Convener, and good morning to you. I'll perhaps leave the victim surcharge to Graham then, and pick up on something else that I wanted to ask. It's regarding the vulnerable witnesses provision, which I think most people I've seen who's put in a submission are saying, whilst it's great it's in the criminal justice system, when you're talking about civil cases, in particular domestic violence and rape and stalking, and also children's hearings and children, asking that this should be within civil justice as well. And I just wondered if some comments from the panel, if they wanted to.
First of all, thank you very much for the opportunity to address you. Yes, we are quite concerned that the provisions to extend automatic entitlement to standard special measures for victims of sexual assault, rape, stalking, domestic abuse, trafficking are not going to be extended to civil proceedings. Now, we've set out in our, obviously in our response, our concerns about this, but being vulnerable does not stop just because you're going into a different arena. Someone else, I think it was Assist, made a very good point that a criminal case can take sometimes 38 weeks. At the same time, a woman is actually involved in, say, a contact hearing. So that may be concurrent proceedings or separate proceedings. Now, you're not going to be any safer just because you are in a civil arena. In fact, you're likely to be less safe because the whole consideration of the criminal issues are completely different. And in fact, you're likely to be even more vulnerable because of the nature of the case. When you think about it, domestic abuse, contact and residence, you have some very personal and probably sensitive information that's being thrown at you, but you're having to sit there and face the person whom perhaps in another arena you didn't have to sit and face. Now that's, I don't think, in the interests of justice. It's certainly not in the interests of evidence being given freely. And of course, we mentioned children's hearings proceedings as well, because of course now the Children's Hearing Scotland Act it provides for the grounds for referral domestic abuse and forced marriage. And in those situations within a children's hearing, if the grounds were being disputed or there was a proof about the grounds for referral, it would be incredibly important that people who are more or less engaging in the system, not necessarily because of their own volition, but also because they have actually referred, are protected.
Just to echo Louise's point, we've never had a civil case for rape today, but I think it is likely that we will have at least one in the near future, and we are concerned about what protections are in place if somebody does go down the civil justice route. I think particularly in terms of rape, people go down the civil justice route are considerate because they feel that they've been failed by the criminal justice route, and I think there are concerns about lack of protection becoming a deterrent then to somebody feeling able to pursue a civil route. I think it's broader than just special measures, because there's real privacy issues here. We don't have any legislative protection in terms of anonymity for rape complainers in Scotland. It's unclear about whether or not that anonymity would also apply in the civil courts. So I think there's a number of issues around privacy that would be helpful to consider as part of this bill that are linked to special measures but are above and beyond special measures as well.
I take you just now, Mr. Morton. Can you just explain how you can bring an action of rape in a civil case? I got a bit lost.
It would be an action against the perpetrator in a civil case for damages against the perpetrator.
Yes, I understand that on the basis that there been a rape. Thank you. Just to clarify. Mr. Morris.
Thank you. Yes, I think also one of the things that struck me with the vulnerability part of the bill, when I first watched the debate last June on the floor of the House, there was some discussion as to what the interpretation of a vulnerable witness is. I tend to go along with Dave McKenna from Victim Support that any victim or witness has the potential to be vulnerable. And I also think that in recent cases which have highlighted this, that you can see that some victims and witnesses can become vulnerable during the process. And I quote the obvious example of the tragic figure of Frances Andrade in Manchester, who was, when she was questioned, said she was quite fine to go in the witness box and what have you, but because of the strength of the cross-examination from the defence lawyers, became vulnerable. So I quite agree that these measures, these special measures, absolutely should be available to all victims and all witnesses, bar none. And if you, rather than trying to say that a certain group of people is particularly vulnerable, if you just classify everybody under that scheme, you won't go too far wrong.
Criminal records that are giving witnesses.
I think if you're looking at emotional, you know, I mean, if a crook is giving evidence and he hasn't committed a crime in that circumstance, then why shouldn't he be vulnerable? If he hasn't committed a crime.
Some witnesses are pretty tough. I'm not saying there aren't extremely vulnerable.
No, what I'm trying to say is that the special measures of giving evidence behind a screen or whatever the special measure, that should be available to everybody. What it is about that you don't?
Because you've got to test the credibility of a witness. And testing it can sometimes rely on body language, the behaviour, the manner in which they do it. Lots of things can happen. I'm not in any way parking really people who are deemed to be vulnerable in all kinds of circumstances, but this idea that all witnesses are some kinds of little frail, little eggshelly people is not the case in some of the criminal courts in Scotland. They're pretty tough guys and women up as witnesses, and their evidence has to be really tested. And I think there are circumstances where they deserve to be seen and heard as well as heard.
Yes, but I mean, I think the specific cases here, which we're talking about, perhaps rape victims, people like that. Stalking victims. Yeah, I know I said all, and I mean the point is, if somebody's appearing on a video screen, you can still interpret their body language through a cross-examination.
I'll leave that one, Sandra.
You know, I was quite happy with the replies I got back. I may come in later on, but I'll leave it at the moment.
Yep.
Thank you.
Graham, followed by John Finney.
Thank you, yeah. And good morning. I think that it would be fair to reflect that the system, if we can describe it as such, has spent a considerable declared time in dealing with matters involving sex crimes and domestic abuse circumstances. So I think that two panel members particularly are in a good situation to report on the experiences of witnesses and victims and reflecting that alleged additional support that's been offered to people who come through that part of the system. You heard the panel earlier this morning giving evidence from their viewpoint. The question I asked them basically was, having read the proposals within the bill, from your own situation and experience, do you think that these proposals, if enacted, will enable witnesses and victims that you've been in contact and your organisation support, will they be better placed in the future? If not, what weaknesses do you identify?
I would say they will make a positive difference. I mean, the key thing for us in these provisions is the ability to give greater certainty to complainers of sexual offences. Automatic entitlement to special measures means somebody knows further in advance what will actually happen when they go to court. Given how nerve-wracking the prospect of giving evidence is in terms of sexual offences, I think that's to be welcome. So I would say that hopefully has been relatively uncontroversial. I don't necessarily know that in itself is going to significantly reduce the documented trauma that complainers of sexual offences experience in going through the judicial process. I think it's always going to be a traumatic experience given evidence of such an intimate nature. I think there's far more that we could do, not least as I've highlighted in my written evidence re-looking at issues of sexual history and character evidence and the increasing use of complainers' medical records in rape trials. It doesn't happen in any other crime. If you report a burglary, nobody's going to look for your medical records to see if you've got a mental health issue. I think there are significant privacy issues still at play for sexual offences that definitely act as a deterrent to complainers coming forward. They're not issues that are addressed by this bill, and I think they are issues that do require urgent attention. I do think one final thing I would say as well is that while there's been significant and very welcome attempts to improve legal responses to rape in particular, nobody is speaking directly to rape survivors to ask them, what was your experience? Have these provisions made a difference for you? I think there's a real dearth of research directly asking complainers what would have made this an okay experience for you, or a bearable experience, because anecdotally what we are still hearing is that it's a very, very, very difficult experience for complainers.
I would actually echo a number of Sandy's comments there. First of all, yes, certainly the extension of the automatic right to use special measures will be of great use, because we do know from women's experiences that they're not used routinely, and they would be of great help in actually supporting women to give evidence. Secondly, in terms of the standards of service and the other reforms, we do know also that bail information is not routinely and timorously given to women. We also know that the conditions of bail aren't, again, timorously or consistently given. I've just mentioned on the assessment for vulnerability. Assessments for vulnerability from perhaps the word go in relation to protection, in relation to use of special measures. Information about cases, delays in cases, churn, etc., the actually be able to appear in court. Now, the standards of service obviously have a great opportunity to really address this, but it depends how they're used, because if we can have all these nice shiny standards and they sit on a shelf, or they have the capacity to change from, we have commitment at the highest level, but it doesn't permeate down to the people in the sharp end who are actually dealing with victims and witnesses on a day-to-day basis, which is why I think, in terms of how we responded, the monitoring conditions that we said should be actually in the face of the bill and stated should be there. The duty to consult with victims and witnesses, as Sandy said, there has to be much more of a consultation with people to say, how did this work? Did we do things when we were supposed to? Did we do what we were supposed to? And did it have the effect that it was supposed to? And also about training. We engage, obviously, with various criminal justice organisations, statutory organisations, but I think that should be much more of a duty. And it's not just about dignity, it's about recognising you're dealing with a person. I mean, dignity, etc., and respect can be are quite, I suppose, nebulous concepts. But what you're talking about is the person in front of you. This person's information is being shared. Think about what's going to happen to this person. You have really sensitive, controversial information that's being sent out into a public arena in front of a whole arena of people that the victim has never seen before and is going to be judged upon. They have to be treated as individuals and as human beings. I think that's the most important thing.
One of the points I was going to raise about the access to case-specific information is there is no mention of timescales and when that information should be passed. Should there be some kind of timescale put there? Because if you don't receive it timorously, as you describe, it's useless to you a fortnight, 3 weeks, a month later. Is that too onerous a responsibility to put on the Crown and others, from your viewpoint?
Well, if they have the information, they could pass it on. I mean, they can only pass on what they have. So either there's the situation of how and when they get the information to pass on. So really, as soon as they have it, they should be, if you're talking about trial dates, witness callings, citations, don't turn up, whatever's going on, that should be passed on probably within 24, 48 hours. If they've got it, they can do it. We have situations just now where women are saying, I've just found out he's got bail conditions. In fact, sometimes he's turned up. Or I'm turning up to give evidence and I haven't got childcare, whatever. You know, there are systems in place just now to do it. I think perhaps the issue is IT. But how do you convey that to people who can't, say, pick up the information via computer, who don't necessarily have a mobile phone? How do you ensure that people get that? It might be timious, but how do you receive it? It's the vehicle in which it's conveyed as well.
What do you suggest? For those who are not How can we help
not
them?
technological. Well, in some cases,
Or don't have the technology.
Certainly, I suppose there could be letters, phones, or even kind of in some cases, it's the police or VIA are supposed to let someone know in relation to domestic abuse. Certainly, bail conditions. Sorry.
No, you're fine.
Okay, right, okay, no problem.
Everybody wants to cheer. It's not a problem.
Cheer. No, sorry. I thought I'd interrupted you.
No, you haven't interrupted.
No, but in terms of that, I think I've lost my train of thought now.
I'll come back to you when you've got it.
Yes.
Well, just before we go to Mr Morris, while we're still on the theme. No, I want to get the best out of our witness. You now put me off my train of thought.
Mr Morris. A tactic worked. Mr Morris, you wanted to come
I
in
seem
while...
to have caused all of this, don't I? Yeah. The only very quick point I was going to make is I just really absolutely feel this completely reinforces my case companion or single dedicated point of contact idea that I've been propagating for some time now. Just on the language terms, I'd rather it be called a case companion, because a single dedicated point of contact is a victim talking to a robot, as far as I'm concerned. So it has to be emphasised, it's personal contact. And the solution to the problem that's just been said is to have that dedicated point of contact that would disseminate the information and would be the go-between.
The point I was going to ask Ms Johnson was that I made the sort of comment earlier that the system would deem that they give the client group that you represent an enhanced service because of the threats they perceive. Would it be your experience that if that's the kind of frustrations the witnesses and victims that you deal with face, that those who are involved in the mainstream of court business will certainly not receive any better service and may well indeed receive a less supportive service?
Well, I suppose all you can do is really extrapolate on the information I'm giving you to say, well, if these cases are identified as specifically requiring, a particular approach, and it's not happening, what therefore is happening in the mainstream? But I don't know.
Experience.
I don't know. That's the thing. As I said, we can only speak from our experience, and some of it is working, some of it isn't. And part of it is about, as I said, having information on time, passing it on, and letting other people know that the information is there. And women shouldn't have to phone up to say when is the case or what's happening. And also, our local groups are having to phone via the Crown Office to find out what's going on and phone about bail conditions. And that really shouldn't be happening.
I think just to say that it makes sense that to get best evidence, you keep your witnesses informed and you support them, and I think that's particularly the case in sexual offence cases.
Final thing for Mr Morris, following on your submission about case companions and so forth, were you disappointed that there was no reflection of that?
I was extremely disappointed.
Just let me finish the final bit of it. Were you disappointed it wasn't reflected within the bill? And equally, that there was no mention of a victims commissioner within any of the bill's detail. Would that have helped?
They were two central planks that I thought absolutely had to be in there. Let's just take the situation that's just been quoted there, that a rape victim's having to constantly ring up to find out when she's going to have to appear. Now, if you had a single dedicated point of contact, a case companion, I would much rather that the grief and the emotional distress go to an organisation than actually go to the victim themselves. So whoever's doing the advocacy, whoever's doing the support, whether it's rape crisis or victim support or whoever, it is much more preferable that they have the problems getting through trying to make the contact and then refer back to the victim rather than the actual victim or witnesses have to do it themselves. That's I think that the most disappointing thing for me, without taking the case companion concept on board, is the lack of empathy that actually case companions are based on a principle that means that prevention is often better than cure. And the lack of understanding to realise that although the victim cannot be prevented from the crime that has been committed against him or her, what can be prevented is the angst that is going into the criminal justice system. and therefore, in agreement with, once again, the Chief Executive from Victim Support, training, he was saying, and I absolutely agree, it needs to be professional support. It needs to be professional support, and it needs to be support that can communicate between all parties, whether it's been between the police, between the courts or whoever, and then we'll start to have a big joined-up, coordinated system. But I felt before that the point you made to the other panel about the victims being passed along as a parcel is absolutely true. It is what happens. You are dealt with by a certain section of the criminal justice system for a certain amount of time. And I think, without being disparaging, that was reflected in their answers. The gentleman who was representing the police force said, for example, that they are trying to follow best practice and what have you. And I've absolutely no doubt that they are. But one has to remember that family liaison officers, the primary purpose of those people is to collate information from the police. Their primary purpose is not to support the victim. They do it in a very sensitive way. They do it in a very family-friendly way, and I'm not criticising that at all. But if you had a single dedicated point of contact, a case companion in place, they could be in a position where, I certainly remember with my family liaison officers, and I was involved with them for 3 years because that's how long it took from investigation to court case, that quite often it could take a month to get an answer to a simple question. And looking back and reflecting on that, it is probably because they had the information, the statement or whatever it was they needed. And although they were trying to conduct best practice, it wasn't their primary concern, it wasn't their primary first interest.
Can I ask you to answer, perhaps pass along to ask for a victim commissioner, which I think you've not dealt with, but I'll ask. You looked as if you weren't in favour of it, but maybe, I read you properly.
Yes, you did, you did.
That's the importance of body language.
Yes.
You see, I could see that, right.
You probably feel it though if I wasn't here. We were not in favour of a victims commissioner, and would probably, I think, reflect to comments that Victim Support made in their response. We already have, along with other organisations, very good links with Scottish Government, direct links to the very senior levels in the Crown Office, the police, so on and so forth. We don't think that another body intervention would have to go through an intermediary would help us at all. Why should we? We know what we're talking about. So in terms of that, I don't think it would be a particularly positive move. And secondly, just to go on from your comment about the case worker or a support person, that's down to really being support organisations being there. And one of the things we raised was in a response that the standards don't mention the terms of the EU directive on support services provision thereof. And our organisations, our local groups rather, do actually have dedicated caseworkers. There are moves with Police Scotland to standardise procedure in relation to domestic abuse across Scotland with multi-agency risk assessment conferences, MARACs, and multi-agency tasking and coordinating groups and all this business to actually give look at risk, look at those who are affected by domestic abuse, and make sure that they do have a response and someone to go to. So there are moves in that. So before we do anything nationally, we have to actually look to see what is already in place.
What's your comment, Ms Brindley?
Just we need to see the detail, I think, of any proposal before we could say whether or not we would support it in terms of victim commissioner.
Yeah, absolutely. I could understand the point that has been made here. The argument I would make is that actual victims on the ground would possibly disagree with that and possibly think that they should have a representative, powerful voice that can lobby parliaments, that can coordinate police, the court services and all the other organisations that are involved to once again coordinate up that system. And also I think that they would feel that many victims that I talk to feel that they're not listened to, they're not heard, and they don't have representation. So although organisations may feel that they're in a proper position to have proper access to the authorities that they need, I certainly feel there's quite a few victims that I know that don't.
Right, well, yes.
Can I very briefly say, I think that therefore is important why the standards should say that there's a duty to consult with victims of crime and organisations supporting them. So there is a mechanism within their standards where people can feedback regularly, not just to go through now and again through an intermediary, but they actually have timed, prescribed review periods. They have to feedback to Parliament, I think it was suggested elsewhere, on their standards, what feedback they have actually gone out and sought and have received and how they did it. So they get a wide spectrum of people responding.
Before we go down the other route, but we'll leave those two.
Thank you.
These two opposing arguments sticking to the wall, as they say, and I'm now not because you're sticking to the wall, Alison, but Alison, it's you now. And then it's John Finn, and then it's Roddy.
A supplementary to the discussion round about special measures, and you've welcomed the extension of special measures, but you'll note that I asked the previous panel about the right to object to special measures, and I'd be interested in your views on why that particular clause is in the bill, what difficulties that will create for the people that you represent.
I think it is already in place under the current system, a limited right to object to special measures. I'm not aware of that limited right causing significant problems, but I couldn't say what the impact might be when it's a more general right.
I think our concern would be if you're having an automatic category of deemed vulnerable witnesses. What we wouldn't want to see is a routine challenge. You know, we're talking about sexual offences, domestic abuse, trafficking, stalking, very emotive crimes where we know the defence do utilise certain procedures, shall we say, and we would not like to see the objection being raised as a matter of course. If you're deemed, and that's it.
Is that your question? Excellent. John Finney, followed by Roddy.
Thank you, Convener. I had a number of questions for Ms Johnson. I have to say the bulk of them being answered very comprehensively. So if I just focus in on two very small points, if I may, please, Ms Johnson, and if the other panel members want to come in. And it was about your evidence about Section 3, disclosure of information. And the bill, it being a right to request but not to receive. Now, you do highlight in that evidence that the bill was developed prior to the EU directive, and you suggest that there should be a statement of reasons for non-disclosure, and you give examples. Could you expand on that a bit for the evidence and why that would be important, please?
Well, certainly. I mean, obviously this comes from it's a translation of the requirements of the EU directive, and given the fact that the directive is saying that victims should have a right to actually receive this information, I think they are perfectly entitled, and in the interests of justice and probably in the interests of the prosecution, or not as the case may be, to receive information as to why or be told clearly why they cannot get information that legally they are entitled to. Because what we don't want to see is it just becoming, we really can't be bothered, and it doesn't happen. If people have to justify the reasons for not providing information that someone is legally obliged to receive, then there will be much more of I think a focus on actually ensuring that information is provided, as opposed to a default position of if we can't get it, we just won't do it. And people have to be accountable.
Who would provide that? The term qualifying person covers the police lord advocate and the Scottish Court Service. Who would you anticipate, or could it vary?
Well, I think it depends on the type of information you're looking for. It could be all of or any individual of these, depending on the type of information you're actually looking for about court times, why a case has been delayed, why a case isn't going forward. And in relation to the event of a decision not to prosecute, the directive is actually different from the bill, because the directive actually says victims shall have a right to review a decision, not just to get information. So the directive in Article 11 goes actually quite further. So we would like that particular right enshrined in the bill.
Clarify what you would mean by reviewing the decision, then.
Well, yes, as opposed to being told we're not prosecuting, or as opposed to being told we're just going to change the charge. Why? Say, for instance, the answer is we don't have the evidence. Why don't you have the evidence? Was it down to perhaps a failure in process? Was evidence not collected? Because people can think, I haven't been believed, why aren't you going to prosecute? So they can also say, well, did you speak to X, Y and Z? Did you get this information? And the whole trail, I suppose, the evidential and investigative trail can be followed, which gives certainty both for the investigating and the prosecuting authorities and also for the victim.
Standards of service.
Indeed, yes, it ties back to that as well.
Does that answer your question? What was said by the Crown? in respect of that, so it is being considered.
Yes.
And I think letters are issued, the wording has changed, letters are issued saying the Crown is taking no further proceedings unless further evidence comes to light. Because at one point they just said taking no further proceedings, and I actually had a case where evidence did come to light but they couldn't prosecute anymore. So at least that caveat is there now, and this would add to it.
Yes, I think it's very important for, especially obviously women, children, young people experiencing domestic abuse who are being told that they will not be believed. You know, the victims of crime who are told you're not going to be believed, nobody will believe you, it's all nonsense. And if this decision is made in a very bald, frank way, without any justification or explanation, that does not help victims at all. And I think it has, as I said, a twofold benefit, one to the victim, but also for process and ensuring standards are followed and complied with.
Yeah, I would agree with that. I do think it's an omission in the bill that it doesn't currently provide for a right to request a review of a decision not to prosecute. It particularly impacts rape complainants. We know that it's only about only 25% of rapes reported to the police lead to a court case. The majority of rape complainants are getting a decision not to prosecute. It can be incredibly distressing, and I think having an explicit right to request a review of the decision not to prosecute could be very helpful, and it does also just give a level of accountability, I think, to these decisions.
I was going to, if you no comment, I'll just move on. Do you want to comment on that?
One comment to make. One of my compatriots, Action Scotland Against Stalking, actually advocates that independent legal representation should be available because that the Procurator Fiscal is there primarily promoting the case for the Crown. So independent legal representation for victims, I believe it is the right way to actually get the victims' rights recognised within the system.
For what purpose?
Well, for the purposes, for example, does a case need to be reviewed? Can you challenge a decision, that sort of thing? And you know, it was. Let me get to the section. This is not something that I am.
It's something that we have been researching how independent legal representation works in other jurisdictions in terms of sexual offences. So, for example, they have it in Ireland under very specific circumstances, which is around sexual history applications. And it's something that we're interested in looking at in Scotland, particularly around medical records and sexual history applications, where they're very contested areas where you could say that the Crown are acting in the public interest, who's representing the complainer's interest. There is potentially a conflict there in terms of disclosure obligations, and often what we're hearing from complainers is that they don't feel that they've got a direct route for protecting their privacy interests in these areas. So I do think there is a strong argument for legal representation. How else could complainers defend or assert any privacy rights in these contested areas?
Enter the court process in a trial? How would
it wouldn't form part of the trial at all, because these matters would be decided pre-trial. So, for example, sexual history and character applications are dealt with at the preliminary hearings. So there's a process there that could incorporate a representative.
Understand now what you mean by representation. Yeah. Thank you. Yes, certainly, Roddy, and then it's Roddy.
Again, it's to Ms Johnson, and it's concerning Section 5 and the right to specify the gender of an interviewer. You've suggested that the present wording may lack some clarity that would be beneficial and suggest an offence involving domestic abuse. You also say that there's been some preliminary discussions. Are you able to update us on these discussions, or perhaps it's too soon, and if it is too soon, can you keep us updated on how they go?
Yes, certainly. The issue with this particular section is it says an offence consisting of domestic abuse. There is no specific offence of domestic abuse, and I had actually met with the government bill team to say this could be problematic because there is no specific offence, so therefore you may have to amend this to say an offence involving domestic abuse. But obviously the best arbiters of this are likely to be the Crown Office and the Police Scotland, because this will give you an idea of if it's something that would be workable. So that's where we are coming from. We raised this with the Scottish Government to say there could be a problem with this definition, but to take it further to see whether where say the Crown Office and the police thought it might be an issue, because if you're saying you can get this particular this right where there's an offence of domestic abuse and there isn't one. You're really torpedoing the whole intention of the legislation, and you wouldn't be able to give it force.
Thank you very much.
And that would apply to both men and women who might be victims of
anybody,
abuse,
yes,
or children or whatever.
Exactly.
Yes. Can I move on now to Roddy, please?
My question's also aimed at Ms Johnson. You comment in your submission on Section 20, the duty to consider making a compensation order. Well, the bill simply seems to make that a statutory requirement. It's already something that exists. It's quite often the case that in cases of fraud or dishonesty, an accused might have repaid sums that he has misappropriated, and that might impact on whether or not, or the nature of the sentence he was given. I'm not quite sure I understand the logic of your position to suggest that a compensation order could not be considered as an alternative to custody. And is that not trying to kind of shackle the judiciary slightly in terms of their approach to sentencing?
Well, I think it's really what the issue here is the victims' right in terms of sentencing. Certainly in relation to cases where there's no domestic abuse, no rape and sexual assault, other cases of that particular nature, considering a compensation order or making a compensation order might be, appropriate. However, we would be very concerned if in every case the court had to consider it, and in cases of the nature I've just mentioned, a compensation order was made without taking the view of the victim, because we know that there are women who would want absolutely nothing to do with the abuser. They've obviously they have fled the abuser, they're living somewhere else, they don't want anything to do with them, they would not want essentially blood money. So there are cases where this would be appropriate, but I think the important thing is to ask the victim. We're going to make a compensation order, maybe in addition to or instead of something else. Would this be to you an appropriate disposal, or really are we doing something that's just going to re-victimise you? And I think the opportunity to make a compensation order instead of something else is a bit of an affront, really, to victims of crime, saying what we're going to do is order compensation, say in a case involving domestic abuse, which you don't want, but we're going to do it anyway, and that's the only disposal we're going to give up to someone who will possibly deliberately string out the payment to make it to really just re-abuse the person, the victim.
Sorry, Peter. Yes, Peter Morris. Sorry.
I wonder if this touches slightly on the victim surcharge. Would I be right in saying that? That compensation, I mean, I've been arguing for some time that compensation should be an automatic right in serious cases. The fact that one has to apply for compensation if you're the next of kin of a murder victim is another thing that you don't want to be having to do when you're going through a court case. The last thing that I was ever thinking about going through my court case was how much money can I make out of this. That was the last thing I was thinking about. And yet, next of kins following a conviction do have needs, sometimes prior to a conviction, sometimes it might be very basic needs such as funeral costs and what have you. In my particular case, it was I would like to have had therapies met and what have you for the anxieties that I've gone through, also for my mother, her needs. And people's needs are as individual as people are. And I think that there certainly is an argument as far as compensation is concerned that levels of automatic compensation should be awarded, in my opinion, after conviction. And this would make the whole process a lot less stressful for the victims.
I think the issue is that would be, I mean, I'm not quite clear of where compensation orders are currently payable, but it does refer to the 1995 Act, Section 249, so there are specific types of cases in law where a compensation order may be made. So there's already judicial discretion, but there's already particular constraints in that discretion under that Act. And I think we'd really need to look at that to see how that impacted what you're just saying with regard to it. But I certainly understand the position I think where you make a very clear case that you can understand why somebody doesn't want anything to do with someone, but it may not in fact apply. Not quite sure. We'll need to look at that, at a previous act, to see if it would apply anyway in the kind of cases you would be referring to.
Just as a matter of
yes.
convener, for clarity, currently just now the court may consider, so it's got the option. What the section is going to do is make it obligatory in every single case. It has to be a consideration. The court just hasn't got the option to sidestep it. It will have to be, I think, discussed.
Can I just say it says here, in section 249 of the 1995 Act, compensation order against convicted person, after section 4 insert, in any case where it would be competent for the court to make a compensation order, the court must consider whether to make it. Now, I'm not quite sure how far that reaches, and I think we'll need to look at that. It doesn't appear to be appropriate in all cases, but I don't know. Well, that actually is concluding this session. Do you have anything which I omitted to ask the previous one that we should have asked and we didn't ask? You're taking a deep breath.
And I'm taking a deep breath. That's not a bad sign. Just catching my breath. Jess, I think I would just like to say that we really would like you to give serious consideration to the civil proceedings, and being aware of the fact that the children's hearings can be dealt with separately from the rest of the civil proceedings. So there is this. I'm glad to hear that the committee is going to look at the whole issue of the court service, because what we're concerned about is the intention and the impact of the Victims and Witnesses Bill will be lessened if victims and witnesses are disadvantaged by the proposed court closures and reorganisations. We are concerned that the protection and safety and access to justice is going to be compromised. There's going to be inconvenience of longer travel times and higher costs, and this will impact adversely on victims and organisations.
Can I say we're going to be dealing with this?
Yes.
You'll have your opportunity when we deal with proposed court closures. I want to keep to this bill just now, surely. Yes.
I had two very quick points. One is about forensic examiner, about the right to choose or have a say in the gender of your examiner straight after a rape or sexual assault. The bill recognises the need or the right to choose the gender of your interviewer in terms of the police interviewer. If we accept that, I think it makes sense. We need to consider provision for somebody to be examined by a female doctor after a rape or sexual assault. It's an issue that's been raised with us for about 20 years at least, as a considerable source of distress, that most women in Scotland and men are being examined by male doctors. I think this is a good opportunity to look at just how can we get a basic level of care that we know meets the needs of complainers. The other point that I've raised in my written submission is about closed courts becoming a discretionary special measure. We're just keen to make sure this doesn't lessen what happens just now, which is that it happens automatically in rape cases. Complainers need certainty that the court will be closed. We wouldn't want to see an inadvertent impact of making it a discretionary special measure lessen the certainty for rape complainers. So I think it's something to consider when you're looking at these special measures, to make sure it doesn't actually lessen something that we want to give more certainty around.
Thank you. Mr. Morris, do you have
a couple of quick points. First of all, referring back to the previous panel when you were talking about victims and accused occupying the same space in a courthouse, I would hope that possibly that discussion could also be extended to examples where I've been involved with, where, for example, victims or relations of murder victims and accused having to live and occupy the same space. I was recently made aware of one victim who had to live in the same road as the person accused of her brother's murder for 18 months. And whilst I accept the point that one is innocent until proven guilty, and I fully accept that, I just think it's an area that he's looking at. I don't accept what I think it was the court service said about it being a very unfrequent occurrence that victims and perpetrators occupy the same space. In my 4 months in Glasgow, I on 4 or 5 occasions had the accused and then convicted murderer next to me in the canteen queue, and I find it very distressing that that level of emotional stress can be put on you during a lengthy process. So that's one thing about that. And secondly, I was looking for, and I don't know if this comes, and you'll have to correct me if this doesn't come under part of the bill, but I have the impression that from where the draft bill came from and what was the consultation process that was produced last June, that went out to consultation process, I didn't see very much difference at all. And I wanted reassurance that if new and innovative projects were in the making, that there would be funding available for them. And I refer specifically to a case companion project that has been designed not by me, but by ex-Procurator Fiscal people and ex-policemen in Ayrshire that are looking to get off the ground with fairly minimal funding, but they certainly are under the impression that no funding is available, and they're having to go cap in hand around various trusts. I'm very keen to support this project. It supports every proposal I have of case companions, and quite frankly, if there was no further funding for any further new ideas to come out, why was that not made clear before the consultation process?
Well, obviously the government consults before it drafts a bill, and we then challenge the bill as it comes before us. In terms of your case companion, obviously if there's something inserted in the bill, there'd have to be funding. You can't put something in and say there shall be a case companion on blah, blah, blah. So the funding would fall. The other issue, if it's not in the bill, obviously is a matter for policy rather than legislation about funding, as you understand from your own organisations in the voluntary sector. So it's a matter of government funding and charitable funding and so on. But I'll leave it at that. You've made a good argument about case companion, which the committee will consider, as indeed the contra argument about a victims commissioner. So we've not missed them. And thank you very much for your evidence, and it's bang on time. And we're moving on to the next item of agenda. Thank you very much. I'm going to move straight on in the interest of time. Item 3, subordinate legislation. 3 negative instruments. The first is the Police Pensions Contributions Amendment Scotland Regulations 2013 SSI 2013/89. The Subordinate Legislation Committee has drawn this instrument to the Parliament's attention on the grounds it was not laid with the required timescale of at least 28 days before it came into force. The SLC sought an explanation from the Scottish Government. Could I ask people to leave quietly, please? The SLC sought an explanation from the Scottish Government for this omission and was content with the explanation given. However, this committee is required under standing orders to consider the letter to the presiding officer on the breach of laying requirements. This letter is on page 6 of your paper 4. Do members have any comments on the statutory instrument or on the laying of the letter to the presiding officers, or are members content to make no recommendations in respect of this instrument?
I think it would be fair to comment that the government did have an opportunity, if they so wished, to change the increase that's indicated within the pension contributions for police officers in Scotland. The Scottish Government have made a major case indicating that they are treating the police service differently in Scotland to their colleagues in England and Wales. So it was certainly within their gift, should they wish, to take a different approach. But having noted that, and noted that they've chosen to maintain a standard approach across the UK, I just feel that that comment needs to be made, as the alternative view is so often peddled out day and daily.
You're very good at putting these comments on the record, Graham.
Thank you.
Yes, John. John's waiting. Then it's Roddy.
Well, it will not surprise you, Convener, that I will give that alternative view. The Windsor imposition south of the border was atrocious, absolutely atrocious, and has had a terrible effect on police morale south of the border.
I'll let you finish your point, then it's on the record, then we'll get back to the business. Right.
So I certainly welcome the assurance that was given by the Cabinet Secretary for Justice in respect of that. I also regret that the Chief Secretary to the Treasury, my own MP, threatened action were any changes to be made to the pension. So I think Graham makes his point for his reasons, but I don't think it accurately reflects the feeling out there.
There's tit for tat. Now, Roddy.
Very briefly, could say if we take an alternative view, it would have had consequences.
Right, so what else do we want to say about this? To making no comment, recommendation in relation to this instrument, having put all that in the record. Right, you'll be happy, champions. Yes. The second instrument is the Scottish Fire and Rescue Service Framework and Appointed Day for Strategic Plan Order 2013, SSI 2013/97. the subordinate legislation was content with this instrument. Do members have any comments? Are members content to make no recommendation in relation to this instrument? Yes. Excellent. Third instrument is the Title and Conditions Scotland Act 2013 Rural Housing Bodies Amendment Order 2013 SSI 2013/100. Subordinate legislation Subordinate Legislation Committee was also content with this instrument. Do members have any comments? Are members content to make no recommendation? Thank you. Item 4 is the Act of Sir Dermot Sheriff Court Rules, Lay Representation 2013, SSI 2013/91, which is not subject to parliamentary procedure. We would not normally consider no procedure instruments, but the Subordinate Legislation Committee has drawn this one to the Parliament's attention on a number of drafting grounds. The SLC was particularly concerned that the drafting of this instrument is unclear because it governs lay representation in the Sheriff Court and is therefore directed at people who are not legally qualified. Do members have any comments? Roddy?
No, just to say that I take the point on board of this Subordinate Legislative Committee in terms of the ease of understanding this, particularly if it's somebody who's not legally qualified has to come account to. But I do take a point also that this whole area is to be reviewed by the new Civil Justice Council. But I don't actually agree with the conclusion of the SLC as to the actual interpretation that they give it, and therefore I don't want to endorse the conclusions that they say under paragraph 15.
So we just note the instrument then?
Yeah.
Okay. Item 5, Budget Strategy Phase. This is, the Finance Committee has written to all subject committees to invite them to identify spending priorities from the Spending Review 2011, in which they would like to receive an update from the Scottish Government. The Finance Committee will collate responses from subject committees and ask the Government to provide an evaluation of performance on the identified priorities, which we can consider as part of our budget scrutiny later in the year. Could I have, oops, I've lost my place. What's my next bit? A number of issues that we might like to receive updates and progress are listed in paragraph 8 of your paper 3. These relate to committee's previous recommendations arising from the budget scrutiny. You can of course come up with your own suggestions, no doubt you will. Do members have any comments on any particular areas they would like to receive progress updates on? This is paper 8. John, yeah.
Yes, thank you, Convener. And paragraph 8 lists them there. I'm particularly interested in the third bullet point about community penalties, and I think there's a lot we could glean if we got some information on that. Thank
you. On page 10, paragraph 11 and 12, churn of cases is mentioned. I think it'd be useful to get an update in relation to the work that's been done and the success or otherwise in reducing churn. And then secondly, there's mention of a matter of urgency there about the use of video conferencing and so forth. What resulted in that urgency from 18 months ago and where are we now?
Yes, and I think that's 2 good points. Anything else?
Captured all the things that we should be pursuing. I was quite content with that.
Okay, so we're happy. Now can I move on now to, I think we're into private now. Yes. We're now going into private session and we will continue this. Thank you.